I want to break down the Citizens United decision because I've been seeing a lot of people cite it and discuss it either incorrectly or incompletely. And I'll be upfront, I think it was wrongly decided. I'm not here just to tell you that. I want to show you why. And to do that, we have to actually understand what the court decided and where the underlying legal theory comes from. And what Justice Stevens saw so clearly, he wrote a 90-page dissent. So let's start at the beginning. So in 2008, a nonprofit called Citizens United produced a 90-minute documentary called Hillary the Movie. It was basically an opposition hit piece on Hillary Clinton ahead of the Democratic primary. So Citizens United wanted to run it on video on demand and run ads promoting it within 30 days of the primary, and the FEC said no. Under the Bipartisan Campaign Reform Act, also known as McCain-Feingold, it's prohibited to run that type of corporate-funded electioneering communication within 30 days of a primary or 60 days of a general election. So Citizens United sued. The case that reached the Supreme Court was originally about something very narrow, whether this specific documentary counted as electioneering communication under McCain-Feingold, and whether Citizens United as a nonprofit was exempt. Very limited in scope, and the Supreme Court could have resolved it on those limited grounds. Instead, after initial arguments, the Supreme Court took the unusual step to order re-argument, and it expanded the question to address the full constitutional validity of restrictions on independent corporate political expenditures. They reached for the bigger ruling, and that decision to reach tells you something about where the majority was already headed. The idea that corporations have constitutional rights didn't start in 2010. You'd actually have to look back at the 14th Amendment. Now, the 14th Amendment was ratified in 1868 to protect formerly enslaved people from state discrimination. But within 2 decades of ratification, corporations were already invoking it for themselves. In 1886, the Supreme Court decided Santa Clara County versus Southern Pacific Railroad. But before oral arguments even began, the Chief Justice remarked from the bench that corporations were considered persons within the 14th Amendment, and he was uninterested in hearing arguments to the contrary. Yeah. Now, the statement didn't make it into the actual opinion, but it did appear in the headnote, a summary written by the court's reporter, not by any of the actual justices. Now, headnotes don't have any legal authority, but over time it was still cited as precedent anyway. And that's how corporate personhood embedded itself into American law. From there, constitutional protections extended to corporations incrementally through the 20th century, with each step expanding the doctrine a little further until the question was no longer whether corporations had rights, but how far those rights went. Now back to Citizens United. The majority opinion was written by Justice Kennedy, and its core holding is this. The First Amendment prohibits the government from restricting political speech based on the identity of the speaker. A corporation is a speaker. Therefore, the government cannot ban a corporation from spending money on independent political expenditures. Full stop. Its reasoning rests on speaker neutrality. The First Amendment doesn't distinguish between types of speakers. An individual can spend money advocating for a political candidate, so a corporation has that same right. It's a clear syllogism. The problem is that it treats two completely different entities as interchangeable and then builds a constitutional rule based on that false equivalence. And now let's get into the dissent. Justice Stevens was 79 years old when Citizens United was decided. It was actually one of his last major opinions before retiring later that year. And he wrote 90 pages. Its core argument was that the majority's speaker neutrality principle was simple in the abstract, but it ignored fundamental principles between corporations and human beings. Corporations can't vote, and they don't have a conscience, they don't bear the burden of citizenship. They exist solely to accumulate capital. So to ascribe the same fundamental First Amendment rights to corporations as to individuals does not treat them equally. It's actually as unequal as it gets. Stevens also had a deep concern about what concentrated corporate spending does to democratic integrity. And he was careful here to distinguish his argument from a simple corruption claim. He wasn't just talking about bribery, a corporation handing money to a politician in exchange for a specific vote. What he was talking about is much more harder to prosecute and much harder to see. The way that overwhelming financial presence in an election shapes what politicians prioritize, who they're accessible to, and what positions become viable. The majority dismissed this as too speculative for a First Amendment restriction. Stevens thought that was a mistake. And then there's the whole foreign money concern, which Stevens raised, in which the majority essentially set aside. If political speech is protected regardless of the speaker, and corporations are speakers, what stops a foreign-owned corporation operating within the US from spending money on American elections? Now, the majority said that existing law covered that. Justice Stevens wasn't satisfied with that answer. Given what we know now about the subsequent dark money architecture, that was definitely a question worth spending more time on. Within months of the Citizens United decision, a federal appeals court decided speechnow.org versus FEC. And that case took the logic of Citizens United and applied it to independent expenditure groups. If a corporation can spend unlimited amounts independently, the court reasoned, an individual can contribute unlimited amounts to groups that spend independently. And thus the Super PAC was born. And not from Citizens United alone, but Citizens United was the constitutional foundation it was built on. The spending numbers tell the story. Back in 2008, before Citizens United, outside spending amounted to roughly $338 million. In 2020, that number reached $3.6 billion. Super PACs are actually the visible part. The darker architecture runs through 501c4 social welfare organizations, nonprofits that can engage in political activity so long as it's not their primary purpose. They can accept unlimited contributions, and critically, they don't have to disclose their donors. They could funnel money into super PACs, which do have to disclose their donors, but if their donor is a 501c4, the original source stays hidden. That's dark money. Now, the majority in Citizens United upheld disclosure requirements 8-1, but what they didn't anticipate, or at least didn't address, was that the disclosure framework can be so easily rerouted through the nonprofit structure. Remember what Stevens said about foreign money. The majority said that existing law handled it, but dark money by definition has no disclosed origin. We don't know who funds every 501c4. We do know that 501c4s have spent hundreds of millions of dollars in American elections. All this to say, Citizens United didn't just change campaign finance law. It handed concentrated wealth a constitutional shield, and we've been dealing with the consequences of that ever since.